Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to talk about California Assembly Bill 1127, the ban of Glock sales, but we're not necessarily going to talk about what it's doing. We're going to talk about something a lot cooler than that. Want to get something right away corrected, which is the enactment date. So, January 1st, 2026 is the date apparently where no more FFL can accumulate any more prohibited inventory. July 1st, 2026 is the date in which none of that can actually be sold. I think that all of that will be long gone. Stock up now if you want to, California. But what instead we're going to talk about is not what the horrible things that this law does, because you guys all know that already, but the first lawsuit to try to undo what is obviously a very, very unconstitutional gun law. So today, let's spend a few minutes, let's go through the complaint, and let's talk about the lawsuit to stop California's Glock ban. Okay, America, listen, we talked about this law. We didn't know, was Governor Newsom actually going to sign it? But of course, has Governor Newsom ever found a piece of gun control legislation that he didn't absolutely positively adore? The question is, of course not. So he did, in fact, sign Assembly Bill 1127. It technically goes into effect July 1st of next year, but inventory is flying off the shelves now, California, so get on it while you can. This will ban the sale of any Glock or Glock-like handgun, Glock clone, anything involving a cruciform trigger bar. And I want to make that really clear that this lawsuit that we're going to be talking about today, which is the matter of Jaymes v. Bonta, newly filed lawsuit by the Second Amendment Foundation. Included in this lawsuit as well is the National Rifle Association and the Firearms Policy Coalition, which means there are links for all three of them down below in the description box. It is filed in the United States District Court for the Southern District of California. It is a constitutional challenge to California Penal Code 27595, which, when enacted into law, will prohibit the sale of any of these firearms that have cruciform trigger bars. And to make that clear, the complaint here, filed by the Second Amendment Foundation, states the following. For the avoidance of doubt, plaintiffs challenge the restricting as to all semi-automatic pistols with cruciform trigger bars that are banned by California under Section 27595A. Okay, now we're going to go through the complaint in rather rapid fire because it's a well-drafted, very precise complaint. But obviously it starts with the fact that, well, these firearms are in common use for many lawful purposes, including self-defense. And if this law is allowed to go into effect, it will preclude access to those arms. And obviously this would be flagrantly unconstitutional, right? Because Heller said that the handgun is in fact the quintessential tool for self-defense in and outside the home. So any ban on any access to these would, of course, on its face, be unconstitutional. So in rapid fire, this is how the Second Amendment Foundation, as well as the other co-plaintiffs here, sum up this very straightforward argument as to the constitutionality of California Penal Code Section 27595 sub A. As Heller made clear, the only historical justification that could justify banning the possession of a firearm is that the arm is both dangerous and unusual. Arms that are in common use are, by definition, neither. Thus, in Heller, the Supreme Court held that the Second Amendment protects the possession and use of weapons that are in common use at the time. All of which is exactly true, and that's why whenever there is this inquiry into the historical analogs to justify a ban, everyone is wasting their time, they are wasting paper, because that historical inquiry has already been made. That's it in a nutshell. The plaintiffs also correctly plead a law that bans the sale of and correspondingly prevents citizens from acquiring a weapon in common use violates the Second Amendment. Semi-automatic handguns with cruciform trigger bars are not different from any other type of semi-automatic handgun in a constitutionally relevant way. The Supreme Court has already held that handguns are in common use and cannot be banned. Quoting, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. And of course, the state of California is going to say, no, it's just these certain firearms, and it's just based on this cruciform trigger bar. Well, again, the plaintiffs correctly plead, semi-automatic handguns, including those with a cruciform trigger bar, therefore cannot be banned. Even considered as their own group, which under Heller they should not be, the banned handguns are constitutionally protected. They are also unquestionably in common use for lawful purposes. In fact, they are among the most popular handguns in the nation. And so even under a fabricated in common use for self-defense analysis, there is no doubt that handguns in general, and these particular brands of handguns, Glock in particular, are in fact in common use for self-defense as well as many other lawful purposes. The complaint goes through a lot of the sales numbers, importation numbers, and things like that. Probably unnecessary. I think that even the greatest anti-gunner in the world could recognize that Glock handguns are, in fact, in common use for all sorts of lawful purposes. The number one purpose, of course, being self-defense. Now, we got to get to the remedies, right? Don't have a lawsuit unless you got remedies, right? What do the plaintiffs want here? In particular, they want this. 1. Declare that Penal Code Section 27595A's ban on semi-automatic handguns is unconstitutional under the Second Amendment, both facially and as applied. 2. Enjoin enforcement of Penal Code Section 27595A's ban on semi-automatic handguns. Okay, the case was just filed once again in the United States District Court for the Southern District of California. The case once again is Jaymes v. Bonta. We'll link up the complaint down below. Remember, links for all three of the plaintiff organizations down below for you to show them some love. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, and in California, next to nothing now, you should know how to get a hold of Washington Gun Law. If you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.